Hey everybody, welcome back to the Starved Rock Murders. I'm your host, Andy Hale. Delighted to be joined again by my law partner, Sally Cohen. Sally, thank you for being here.
Thank you for having me again.
So for everybody out there, I first want to share some good news. Some people may know about it, but a lot of you probably don't. So I did this, 3+ hour PowerPoint presentation on the Starved Rock Murders. I gave it at Grand Bear Resort in Utica back in December. It was so thorough, so factual, so enlightening. We had a great turnout. Unfortunately, it was a little bit of a blizzard that morning, so I know a lot of people wanted to be there and couldn't. A lot of people who aren't local wanted to be there and couldn't be there. Well, here's your chance. You can watch it on my YouTube page. We're going to have new episodes every Tuesday. The first 2 episodes are out. The episodes are 15 to 20 minutes long, so it's going to take probably about 10 episodes to cover the whole presentation. But if you're interested in the Starved Rock Murders, I urge you, I beg you to watch this because it'll really be an eye-opener. I think a lot of people, even people who kind of follow the case, will be shocked to hear some of this evidence that we've discovered. So check it out. All right, today, Sally, I want to talk about I'm going to coolly and calmly walk through some evidence today, but I want to start pointing out how the state, in my opinion, intentionally, deliberately manufactured a case against Chester Weger. In this episode today, I just want to talk about the scratches evidence because scratches evidence was a big part of the trial. We're going to talk about that. But I just want to walk through this today, talk about what the evidence was, and then I'd like to get your thoughts on the way the scratches evidence was argued by the parties recently, us and Will County, and how the judge handled the scratches evidence. Are you with me?
I'm with you all the way.
Okay, so let's start out factually. When the women's bodies were discovered, within days, there was a meeting with John Shake from the Illinois Crime Lab and law enforcement talking about the forensic findings from the crime scene. It would mention the log, the qualities of the log, how much the log weighed, the cord around the women's wrist, all the forensic physical evidence. And one of the things noted, and I'm holding up, there's notes of that meeting. These are notes from March 21st, 1960. I've highlighted part of it. What was noted was victim A had gloves on. Victim B had a glove on on her right hand, and victim C had gloves on. So keep that in mind when we talk about the scratches evidence. I think people picture like fingernails, digging into skin. And I want to note initially that of the women's 6 hands, 5 of those hands had gloves on them, which I think a gloved hand, I don't think is going to cause scratches like nails would. So that's kind of my first kind of contextual point. But here's the next point. This is the most important, and people don't know about this. I'm holding up a 2-page document, and it is a 2-page memorandum from the Illinois State Police. And at the top, it says, interview conducted by Sergeant Hall, Corporal Raisins, and Trooper Lothorpe. The subject is Chester Otto Weger. And the dates are March 18th, which is 2 days after the women's bodies are found, March 20th, and March 28th. And what this 2-page memo does is it summarizes the conversation and the interrogation that the Illinois State Police conducted with Chester Weger on those dates. So Chester, like all lodge employees, was interviewed on March 18th. Well, a lot of lodge employees were interviewed initially, March 18th. And then Chester was actually interrogated, meaning you're looked at now a little bit more treated like a suspect for 2 hours on March 20th. Okay, so let's pause there. First of all, these are law enforcement officers, and they're treating everybody who worked at the lodge as a potential suspect. They're thinking, hey, maybe this is somebody that worked at the lodge. So you're looking at these people with an eye towards, could this person have committed the crime? So not only are they being interviewed and interrogated, these employees, they're also being observed. These Illinois State police officers are sitting literally across the table from Chester Weger for hours talking to him. And any trained investigator, part of what you're doing is you're making physical observations. Is the person making eye contact? Do they seem confident? Do they seem like they're holding back information? You're observing their physical features. I want to note, and this is so important, there is nothing in this 2-page memo describing any physical characteristics of Chester Weger's face. There's not a mention of scratches. There's not a mention of bruises. There's not a mention of cuts. It doesn't even come up. And there is no way, would you agree with me? There is no way Chester Weger would have had a severely cut, bruised face if he had that it wouldn't have been noted in, first of all, during the hours he spent with the Illinois State Police, and wouldn't have been documented in this memo. Would you agree?
I would absolutely agree.
What are your thoughts on there's nothing in there about that?
Well, I mean, certainly the conclusion is that there was nothing on his face that raised any alarm. I mean, I don't think that they were hiding the ball. They were trying to gather evidence.
It's just so clear. It's not even a debatable point. I mean, it's just not even a debatable point that there's nothing noted, which means there was nothing significant. There was nothing. And a lot of people don't know that, and I don't even think John McNamara knew that, because I don't think he had a copy of this memo. I believe this is one of the documents that I only got when I was tipped off that documents had been donated anonymously to the LaSalle Historical Society. And then I went and looked at those documents, and this was one of them. I wouldn't have known this either. And my point is, if McNamara didn't know it, then he was really at a disadvantage, because this would have been such powerful evidence by omission that he could have raised a trial. I'm going to talk about that a little bit more. So as we've talked about, the case is unsolved. The first big break is John Kovalik seeing the women talking to a guy on the side of the road, 2 or 3 people in a car. I mentioned this in my presentation, people. Watch my PowerPoint. And then the next bombshell that we've talked about numerous times, and we'll probably continue to talk about, is the Lois Zelensik telephone operator who overheard 2 men talking about the kid with bloody overalls in the trunk of the car. Not sure what to do with them. Get rid of them, burn them. They traced the call. The call is placed from a bar in Aurora owned by Glenn Palmatier. The call's received by Glenn Palmatier's brother, William Palmatier, in Peru. Okay. They are clearly prime suspects. They know who has the bloody overalls in the car. They know, and we know it's William Palmatier for sure knows this, because the call's traced to him. So these brothers know who's involved. But as I've said many times, they evaporate in late August, early September. And that's when the powers that be now have to find a patsy. They know that the real people have been mysteriously, there's been a cover-up of the real people. And now the sights are set on Chester Weger. And so what happens is, starting in October, the state's attorney's office starts interviewing lodge employees, like looking for dirt on Chester Weger, asking them questions about, did he make a pass at you? Did he seem weird? Like really digging and part of what they're asking everybody is, did he have scratches? And there's this relentless questioning, leading questioning and intimidation to try to get people to say Chester had scratches. And my point is, if we pause right there, why are they even asking that? Like, this is what I want to know. There is no contemporaneous report of Chester Weger having scratches. And before they interview all these people, there's nothing in the record about Chester having scratches. So what are your thoughts? Like, why is this even a topic when State's Attorney Armstrong is interviewing all these people and he's saying, like, are you sure you didn't see scratches? We've heard about these scratches. I mean, I'm really asking you this honestly, like, what is he talking about?
Right. Well, I mean, to me, it sounds like they were trying to gin up some probable cause to arrest him, which they ultimately did without probable cause. If they had had the scratches evidence that they say they got later in the beginning, they could have arrested him right then if that's what they were going to use as a basis to arrest him and put the additional pressure on getting a confession. I think that all this pressure on witnesses, they probably wanted more from them than they were even able to get about the scratches. But I think it was, a tactic in the same sort of systemic ramping up of pressure on Chester that we've seen in other ways too at the same time period.
And I think what gets lost, it gets lost on me when I start to think about this. Like when you hear that, okay, the state's attorney's office was kind of interrogating lodge employees, trying to badger them to get dirt on Chester, including evidence of scratches. Let's pause there. In October, why Chester Weger? They're only doing this. These interviews are Chester Weger specific. They're not asking questions like, did you see any lodge employees with scratches? Did you see anybody that looked like they may have had some unusual physical characteristics? No, these are all interviews directed specifically to Chester Weger. So my question is, why in early October is Chester Weger the guy? He is now like the guy.
Right. I mean, I think it has to do with the demographics here. And they saw him as an easy target, dirt poor dishwasher. And they were able to concoct another factually inaccurate theory about the twine and the kitchen and who works in the kitchen. It's Chester. And they targeted him, I think, because he was an easy target. And it's very sad to take advantage of a more vulnerable person. But I think that's what they were doing here. That's why it was Chester Weger.
And it kind of goes glove in hand with Chester gets administered this polygraph in late September by Stephen Kindig, who, as I talk about at the presentation, turns out he was friends with Robert Murphy, the husband of Frances Murphy. He worked for John Reed and Associates. John Reed and Associates hadn't administered any polygraphs yet. These are secret polygraphs that Harlan Warren is now instructed to have done with his handpicked polygraph people. And Chester Weger has passed 6 polygraphs already. 6 already. And now they're giving him a 7th. And I just want to note for listeners, I talk about this in my presentation too. I hired a polygraph expert, John Palmatier, who he gave numerous opinions, one of which is it's very, very suspect that Chester would fail polygraph number 7 when he had passed the first 6. So keep that in mind. So I want to note here, they've got this targeted campaign against Chester Weger in October, but this is a broader point. The state's attorney, the LaSalle State's Attorney's Office knows, and they would have read the same memo I just talked about, that the 2-page Illinois State Police memo that's got the dates of March 18th and March 20th and March 28th of the interview with an interrogation with Chester Weger. And they know that there's nothing in there about scratches, bruises, cuts on Chester's face. They know that. And they know these are trained law enforcement professionals. So my argument is, I believe it was bad faith. It was intentional. They intentionally ignored that powerful evidence that Chester had no cuts, bruises, or scratches. They knew that. But yet they intentionally solicited knowingly false and misleading evidence. What is your thought about that?
I mean, I agree, certainly. And when you read the way that they were questioning the witnesses, not just back in October, but also at the trial, you can tell that not only are they trying to elicit information about scratches that probably didn't exist, but also trying to sort of time the evidence. So, I saw him on the 21st. Okay, so was that bruise yellow? Because his condition might change if he actually had scratches on them. And sort of leading the witnesses to not just say something about scratches, but to say what they wanted them to say about scratches. So it goes even one step further, trying to get all their ducks in a row. It wasn't particularly successful because the witnesses still testified completely inconsistently about the nature of the scratches. But it's not hard to see their method here when you look at the way that they were asking the questions.
The other point I want to make is most of these witnesses, the testimony was simply like, oh, I walked by him and I saw this. I peeked in the kitchen and I saw that. When he walked by me, I saw this. These are these like fleeting moments, right? The Illinois State Police on March 18th are literally sitting feet away from Chester Weger. On March 20th, they say it's for over like 2 hours. So talk about the opportunity to observe. It's the Illinois State Police that had this opportunity to observe. These lodge employees, these are people that, worked in the dining room, worked in like all different parts that had these fleeting moments of seeing things with Chester Weger. So it's not even credible from that standpoint. But yet the state, in my opinion, knowingly manufactured scratches evidence that it knew could not be credible because it knew that the state police had spent hours with Chester Weger days after the murders and hadn't noted any of this thing. And like I said, there was nothing at trial elicited from anybody about there being a contemporaneous report of these scratches. These people are getting interviewed 8 months later when the case hasn't been solved, the Palmatier brothers have evaporated, and now Chester Weger's in the crosshairs of Harlan Warren. So let me continue now. So the state actually, Craig Armstrong, LaSalle County State's Attorney's Office, at Harlan Warren's direction, develops this evidence. And again, why is a state's attorney doing this, Sally? A state, and just a little kind of government 101 for people. A state's attorney's job is to decide if there's enough evidence to bring charges, and if there is, they bring charges. So here in Cook County, for instance, there's a felony review unit. The police will go to the Cook County State's Attorney's Office and say, hey, here's our evidence. We think person A committed this crime. The state's attorney's felony review unit has 3 choices. They can say, yes, I agree. We're going to approve charges. B, I don't think you have enough. We're not going to approve charges. Or C, keep investigating. I think you're onto something. Keep investigating. The state's attorneys are not out there interviewing witnesses. They're not investigating the case. That's what law enforcement does. That's what the LaSalle County Sheriff's Office is supposed to do. The state's attorney's office only prosecutes cases once the cases have been turned over to them and they determine there's probable cause. So it's also very, very fishy and very odd that Harlan Warren in September has now started this rogue secret investigation using deputies Dummett and Hess and Armstrong's the state's attorney, to do this secret investigation when it's not the job of the state's attorney's office.
Right.
And the Illinois State Police now have kind of just, I don't know what they're doing exactly. Harlan Warren does get them to conduct surveillance on Chester Weger in October, so they follow his orders, but that's not Harlan Warren. He shouldn't be doing that. So I want people to understand the oddity of that too. Okay, so I want to just continue with the trial, and then I'm going to turn it over to you to talk about kind of the law. So I just want to highlight for people how outrageous, bearing in mind with what I've told you about there being no evidence noted by the Illinois State Police in the hours they spent with Chester Weger in the days after the murder. These people, the state elicited this testimony at trial. Irma Bazinski, who worked in the kitchen, said, and I'm reading literally all this, I'm going to read from the trial transcripts. This is factual. He had scratches up above the eye, some on the face, and on the neck, and quite a bruise under the right eye. It was yellow. Let me read that again. I mean, think about how outrageous that is, that she would say that, knowing that none of this is noted contemporaneously. Scratches above the eye, some on the face, on the neck, and quite a bruise under the right eye. It was yellow. Are you kidding me? If Chester Weger had that, you don't think the Illinois State Police would have noted that? I mean, it's just stunning. That's Irma Bazinski.
Taking a photo of it,
Yes,
They didn't need to write down they have cameras in 1960.
Great point. Absolutely. Mark Locus. I remember an outstanding scratch high on the cheekbone. John Costello. It was a long scratch, about 3 inches. I could see blood. I mean, oh my gosh. Glenn Kamati testifies a large bruise or scratch, high on the cheekbone, several small scratches. I noticed it right away. Emil Bohm and said he had scratches on the side of his face and one on his chin. Maddie Robinson testified a greenish yellow bruise around the eye. Lewis Reeves said she saw a bruise, a bad bruise, and scratches all up and down his cheek on both sides. And she said they look like long scratches. I got to keep going. Oliver Medio, cuts all over his face. And they said a cut above the eye. Earl Hack, it's interesting. He's called by McNamara. Earl Hack gives Chester a ride home on Monday. It's the day the women were killed. He doesn't notice anything on Chester's face. And on cross, State's Attorney Riccouli is like, well, it was dark in the car, wasn't it? Blah, 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 you know. Well, they've got to leave the lodge together in the light. But anyway, he then claims the next day, on Tuesday, he saw marks on his face, scratches on Chester's face. Okay, so what I read you, if you didn't know about the Illinois State Police memo, which the jury did not, that is pretty dramatic, damning testimony, is it not? Like, it really sounds like this person got in a fight. It was a violent confrontation, scratches, bruises, cuts, both sides of the face, you know. I mean, it really was powerful evidence to try to corroborate the confession. And every time I think about this, I'm so stunned at the, in my opinion, deliberate manufacturing of this evidence that the state knows. They know it's not credible. And you know what? I mentioned how that Illinois State Police memo was authored by Sergeant Hall, Corporal Raisins, and Sergeant Lothorpe. All three of those men testified at trial. And none of them said anything about scratches, cuts, bruises. They weren't even asked about it. The state didn't ask them. Like, it'd be one thing to say, okay, you know, we're going to get them to say it at trial. Like, yeah, Chester had all these scratches and bruises. Well, you didn't put it in your report. Well, you know, I didn't put it in the report then because I just, you know, I don't know. I should have, you know. I thought maybe you'd see that. But this just goes to show you the state knew they were not going to get these three Illinois State Police guys to say Chester had scratches, bruises, and cuts because they knew they didn't see it.
Well,
Chester didn't have
they
it.
knew that they couldn't say it, or they knew that even if they tried to elicit that from them, they would be impeached with the document that they didn't want to give to the other side. There's all sorts of things that make it sketchy on sketchy.
Right, and see, McNamara did not have that document because McNamara could have. It would have been such a devastating cross. It would have been Sergeant Hall. Did you interview Chester Weger on March 18th? Yes. When was that? How many days after the bodies were found? 2 days after the bodies were found. How far were you sitting from him? 2 feet away. How long did you talk to him? For an hour. And were you sizing him up? Were you making observations about him, his demeanor, his physical appearance? Yes, I was. And you didn't notice anything about scratches, bruises, cuts, etc., did you? No, I did not. I mean, that would have just literally, not only would it have impeached all the scratches evidence and made it non-credible, it would have done more damage. It would have literally impeached the entire case. Because I would then get up there in closing argument and say, ladies and gentlemen, let me just make this clear. The state troopers' impeachment of the scratches evidence not only shows that the scratches evidence was intentionally solicited in bad faith. This whole prosecution is in bad faith. Everything here, and that would have been your theme. And so it's one of those facts, Sally, where everybody out there, I'm just trying to educate people and share with them more factual information that they're not aware of. And of course, I don't expect them to be aware of. Why would they? To put all the scratches stuff in context. And when you hear this, there is no other side of the argument. There is no valid, credible response to what I'm saying. There just isn't. It's just stunning to me.
Right.
And so what I want to get to now is that's the scratches evidence. And like I said, I read you all those employees that testified. I mean, how many was there? 6, 7, 8 people. It was that was very harmful testimony to Chester Weger that was falsely and fraudulently elicited, in my opinion. And it gave the state an argument that there was corroborating evidence for the confession. So now I want to fast forward to the post-conviction context where we now are presenting new evidence to the court. And I want you to explain what the judge's role is in how he handles the new evidence and the trial evidence. And so technically, I don't know if this when I mentioned this Illinois State Police memo, okay, I look at it as being new evidence to Chester Weger because he didn't know about it. Yeah, it's from March 18th, March 20th, 1960, but I still think it's new evidence. And it's clear that he didn't know about it because McNamara never used it or referred to it. But that Illinois State Police memo puts in context the scratches evidence at trial. And it basically, in my opinion, eviscerates the credibility of it. But explain a little bit about what is the judge's role here? How is the judge supposed to handle all of this legally?
Right. So as we've discussed before, the actual innocence standard has 4 prongs, but the most important one is the conclusive character of the evidence. And the conclusive character element requires that the petitioner, in this case Chester, present evidence that places the trial evidence in a different light and undermines the court's confidence in the judgment of guilt. So because you have to present evidence that places the trial evidence in a different light, that necessarily requires that you assess the strength of the trial evidence. So that's point 1. And so just by way of example, if you have 2 different murder cases, and in each case the defendant comes forth with new DNA evidence that there was a foreign hair at the scene of the crime. In case 1, let's say there was no DNA evidence presented at all. But in case 2, you've got evidence of the defendant's DNA on the victim, underneath the fingernails, and they also confessed, and cell tower data shows that they were at the scene of the crime. That hair in the same case, in 2 different cases, will have a different level of conclusive character. In point 1, it changes the outcome of the case. In case 2, it doesn't, right? So to make the determination of whether that hair is conclusive, you have to assess the underlying evidence at trial. You cannot not assess the underlying fact at trial and make this determination. And that's what the courts have said time and time again. That's what the standard is. You have to weigh the evidence at trial.
And so here, I know the way this worked was we put on our new evidence in an evidentiary hearing. It was 3 days. The court then gave us time. I think Will County wanted this, but we did it too. They just wanted time to file a written kind of brief summarizing the arguments. And then after we submitted the written briefs, shortly after that, we had oral arguments. And so I know that Will County, in their brief, it was what they filed was called, this is filed March 23rd, brief in support of denial of defendant's post-conviction claim of actual innocence. And I'm reading from Will County's brief on page 4. They say, furthermore, several of defendant's co-workers at the lodge testified to his presence at the state park that day and the fact that after the murders, defendant had scratches and bruising on his face, including Chef Glenn Kamadi, fellow dishwasher Irma Bazinski, Louis Reeves, Mark Locust, Maddie Robinson, Emil Bohm, Earl Hack, and Oliver Bediode. Irma testified she saw scratches above the eye. Okay, so Will County, and they're also on page 44, they say, furthermore, and in talking about Victoria Hobnock, her statement is 8 people testified at trial. They saw the scratches on the defendant's face. So Will County is simply in their brief citing the testimony from trial and saying, hey, there were scratches noted. And Will County did not note or respond to what we said in our brief, because our brief, we made all the arguments that I just made here, that the Illinois State Police didn't note any of these scratches, so it wasn't credible testimony. So what do you kind of make of the way both sides presented it before we get to the court opinion, like the way we presented it and the way Will County responded?
Right. So I think it's interesting that Will County did not address our arguments at all. Really what they are saying here is, here's the trial evidence, and because the Supreme Court, using the same evidence, without any new evidence, affirmed Chester's conviction in 1962, that there's some air of legitimacy to the evidence. What we presented is evidence that places the trial evidence in a different light. That memo that shows that the troopers did not note any scars or scratches or bruises on Chester's face places all of the scratches evidence in a different light. That was what we had to present, and that is what we did present. They only addressed the trial evidence. The trial evidence, which was weak because of the evidence that we presented. So they really just asked the court to rubber stamp the verdict.
Yeah, I think, in cases I've litigated, when somebody does not respond to your argument, it's a concession. To me, it's like you're conceding that there is no argument to make. I always, in my long career, I would always try to respond to something in some way, because otherwise they're going to note, in an argument, they didn't even respond, Your Honor, to what we said. And here, Will County chose to ignore that Illinois State Police memorandum from the interviews of March 18th and 20th. I think that was very telling that the state ignored it. I think they had a duty and responsibility to address it, and they didn't. They chose not to. But I think that's very, very telling. And let me pause here. I just thought of this just now. Sometimes, there's so much evidence here, your head gets a little bit like, there's so much we've uncovered from the hair evidence and all these different things. Because primarily, I've looked at this case as a DNA exoneration based on the hair found on Mrs. Murphy. That's a male profile, not Chester Weger. The genetic genealogy links it to one of the 3 Bray brothers. But let's pause there. I think you could make an argument that if all we had was this Illinois State Police memo, okay, I would argue that that is enough, because you already have at trial Chester Weger denying the confession. The confession is ridiculous on its face, makes no sense factually or with the physical evidence. There's already evidence in the record of coercion. The Illinois State Troopers testified to how they, surveilled Chester 24/7. There's already testimony from Chester about how he was interrogated for hours and hours and hours, how he was threatened by Bill Dummett. Bill Dummett lies, denies it, and is impeached by Craig Armstrong. So you already have strong evidence kind of refuting the confession. But what you don't have until that Illinois State Trooper memo is something attacking the scratches evidence and showing the bad faith. And I actually think you could file a post-conviction petition and have a very strong argument that simply that memo puts the scratches evidence in a new light, and then knowing that the state would go to such lengths to manufacture that false and fraudulent testimony makes you look at the whole case in a different light. And I think a judge fairly looking at all this, I think you'd have a very good chance of getting the conviction vacated.
I agree. And I mean, that's on an actual innocence petition, but you certainly would have a good argument on a constitutional violation of Brady or the common law duty that existed at the time to turn over exculpatory evidence. And a Giglio claim, again, later case, but this reflects on the credibility of the testifying state witnesses. So
Right.
You have a million claims. You could certainly have a whole petition chock full of claims just on this memo.
I want to ask you a little bit about now. Let's turn to the court's order, and it was this lengthy, I don't know, was a 32-page opinion that the court had prepared and then read in court on June 18th. I was going to read some of it unless you've got it with you.
I do have it with me.
So if you have it with you, can you flip to page 7?
Okay, yep, page 7.
So let me kind of set this up for editing purposes. So Sally, I want you to read and then explain in the court's June 18th, 2025 order. And for everybody out there, this is the order where the judge denied our post-conviction petition and in a 32-page opinion explained the reasons why. On page 7, 4 lines down, when the sentence starts, the court believes it prudent to mention. Can you read that sentence and then explain your thoughts on whether that what the judge is saying is correct or incorrect?
The court writes, the court believes it is prudent to mention at this juncture that a third stage evidentiary hearing is not a retrial of the case, nor is it a chance for the court to reweigh the evidence and substitute its judgment for that of the original jury. The 12 men and women who decided this case in 1961 had the ability to observe the demeanor of the witnesses and their manner of testifying and reach their verdict after considering all the evidence presented. He says that without any citations. So what he believes it's prudent to mention is essentially an announcement of a standard that does not govern actual innocence petitions whatsoever. And there's a reason for that, which is because it is the court's duty to reassess the evidence considering the new evidence. So the fact that the 12 men and women of the jury decided the case is irrelevant. In fact, inherent in an actual innocence petition is the concept that the person was found guilty by a jury. So, I mean, it's really what he is suggesting is that he is going to take the jury's verdict as unassailable because jurors were able to observe the original evidence, and he's not going to question the original evidence, even though that is what the law requires him to do.
So let me give you an example. Yeah, the jury saw the 8 people from the lodge testify to the scratches, and I'm sure they testified, if they're good actors, like, oh, I saw these dramatic scratches and things. Yeah, that's all true. But when you now consider the Illinois State Police memo, that the Illinois State Police within days, after spending hours with Chester, didn't see any of this, that makes that testimony not credible. So the fact that the jury believed it doesn't matter and doesn't defeat our evidence. I mean, the whole point is, yeah, we've got new evidence that puts that evidence in a different light and makes it not credible. And the judge seems to be saying, well, that was the evidence at trial, and they believed it, kind of like locking the doors to the courtroom shut and not letting any new evidence get into that courtroom to be put in context. Like the judge just keeping all of that out of his consideration, to me.
Right. And, I've heard the standard phrase in a different way, which is the question is what a new jury would do considering the old and new evidence together.
Right.
And here the judge is saying, nope, I'm not going to consider what a new jury would do. I'm only going to consider what the jury did. And
right.
You can just see on its face how that's a legal standard that can't possibly exist in this context because every person with an actual innocence petition coming before the court will have been found guilty.
Exactly. How else can you win? Under the judge's standard, you could never win because in every post-conviction case, there's been a guilty verdict. So, and if the judge's standard, well, this is what, the jury heard all the evidence and this is, they saw the witnesses. I'm not going to decide whether they were right. You could never win. I mean, it's so stunningly improper. I was really surprised that the judge would basically write that down and claim that was the proper standard when we had actually filed, for everybody out there, we had filed briefing, before the case, arguing, setting forth the proper legal standards. So the court had them, Will County had them, and so it's not like the court wasn't aware. I mean, we gave the court the research of the right standard. The court just chose not to adopt it.
Well, and to say that without a citation, again, for the listeners, it's a little bit into the weeds, but it's a concession that that's not the law, in my view. To cite a legal standard with no citation as prudent is lazy, and it's wrong.
And just to explain a citation, so explain precedent in case law. So what? There's precedent for certain rules of law, and you cite it in support of your arguments.
Yeah. So basically, the law builds up case by case, sort of in an ad hoc way, but you have to refer to authority to decide a case or an issue at law. So basically, usually in the legal standards section, it's all quotes from other cases.
Right. Because how many times you've had an argument and the court says, well, do you have a case for that? Mm-hmm. I mean, a lawyer can say whatever he or she wants. And the response from the court always is, well, do you have a case for that? And when somebody says no, then the court's like, okay, well, I'm going to ignore that, So the fact that there's no citation here is telling, because there is no case law saying what the judge is saying. That alone right there tells you how what the court is saying is not the standard. Let's also look at page 11. There's a reference here, and it's in the context of it's talking about the confession. It's talking about Roy Tyson, and the court says there were multiple witnesses who corroborated his confession by testifying to seeing scratches and bruises on his face in the days after the murders. And what's so frustrating about that is the court is saying that as if the court was unaware of the 2-page Illinois State Police memo dated March 18th and March 20th that I've just talked about ad nauseum. The court is just acting like it's not even aware of that and just taking the scratches testimony at face value. I mean, what was your reaction to when you read that?
I mean, again, here it's lazy, it's intentional, and it's rubber stamping, and it's which is the exact opposite of the standard that he's supposed to apply. In so many, I struggle to think of other examples other than the one that happened right here, but this is a perfect example of why you don't just rely on the jury verdict, because there's evidence out there that undermines it and undermines your confidence in it. That this is exactly the case in which we have new evidence that would undermine the court's confidence in the verdict of guilt. Guess who didn't have that? The jury or the Supreme Court when they rubber stamped the guilt finding. Right.
That's a great thing, because I know there's people out there who are like, well, the Supreme Court found this or that. The Supreme Court didn't have in the record the evidence we're talking about. And let me put this in a different hypothetical that kind of shows more of like how ludicrous the judge's position is. What if we developed evidence that those 8 witnesses that testified at trial were bribed? They were all paid $100 to testify to that. What if somebody came forth like a whistleblower person and said, you know what, I worked at the state's attorney's office at that time, and I overheard a conversation where Harlan Warren said, we'll pay all these people $100 if they testify they saw scratches. And that's what happened. Okay, and we presented evidence of that. Under the court's reasoning, it'd be like, well, there were multiple witnesses who corroborated the confession by testifying to seeing scratches and bruises on his face, so that's that. Like, to think that you can't consider the context for how the evidence came about is absolutely ludicrous.
Right.
Like, of course you can.
Right. In fact, you're required to. And
yeah, right. Like, not like, hey, maybe you want to. You're required to.
And I clerked, as we've discussed before, for a judge, and when we would go through the briefs and make recommendations on how to decide the case, you must respond to every issue raised by the parties that is relevant to the decision at hand. So you can sort of say, we're not going to address X, Y, and Z issue because it's already resolved by a previous thing, but you can't just choose to ignore dispositive issues in the case. Here, this is what the judge does. He doesn't say anything about our arguments about the memo. He just says there's corroboration when our argument is that the corroboration is undermined by our evidence.
Right. So having said that, and I want to pivot to our last topic. So having said that, to how the judge just wrote what he wanted to write without citation, a standard that was not the correct legal standard. We actually, I want to talk about when the judge issued his ruling, we decided to prepare a motion for reconsideration that was filed, but then because it was filed shortly after Chester had died, apparently, Will County argued it should be stricken from the record, and the court struck it from the record, so it's not part of the record. So, but I want to refer to like the argument that we make in here about, and I remember the wording, and I remember the wording that was used. That let's pause for a while. I just find this exactly. Oh, here. I think we said something like the errors of law contained in this court's order are shocking in both quantity and character, and taken together lead to the disturbing conclusion that the court was invested in a predetermined outcome that could only be reached through intentional disregard of well-settled legal standards that govern actual innocence claims. Do you remember something like that?
Yes, I do.
Explain what, I mean, I think it's pretty obvious. It's kind of self-explanatory, but explain kind of the intent and mindset behind that.
Well, yes, as the listeners know, I mean, we were already aware at the time that Chester was in very poor health, so that we were probably going to lose our opportunity to appeal. But so when you file a motion for reconsideration, you're asking the court itself, the trial court, to reconsider its opinion based off of errors in fact or law that were made in the order. And so here, we're saying there were so many that there's an even bigger error at large here that's operating here, which is that it very obviously appears that the court backed into its legal reasoning from the outcome, not the other way around.
Meaning what? Like, I'm going to deny this and let me find a way?
Yes. And couldn't find a way to do it without creating a legal standard that does not exist and using that to deny it. There is no way that he could back into denying us relief using the standards that govern actual innocence petitions. If he applied the standards, it is impossible for us to have lost. So he made up a new one and applied it. And then went above and beyond by ignoring the evidence that we presented. So he applied a totally false or non-existent legal standard and then still didn't even apply it to dismiss our evidence. It just went against, just decided not to address half our evidence.
Yeah. Oh, boy. So it's Chester. I just want to say this when you talk about him passing. I miss Chester Weger so much. I miss him. Think about him every day. Rest in peace, Chester. Know that this legal battle continues. You know, we're still talking about the case. We're not done. But I think it's so frustrating that if Chester would have been a healthy, vibrant guy, and we got this court opinion, although I would have been equally as shocked and surprised at the wrong legal standard that's here, I also would have had the opinion, you and I would have walked out of court like, well, this is 100% getting reversed. Like, even though you've got the issue of we got to now go through an appeal that's going to take a year or two, I would have been extremely confident that not only was the case going to get reversed, we'd probably get remanded to a different judge, you know?
Yeah, and part of the thing that makes it extra, disappointing and sad is that I don't believe that the judge would have felt like he could so brazenly flout the law and write this order if he thought that Chester would survive for us to have an appeal.
Yeah.
And that is, again, just disappointing to say the least. That would be how.
That's the nicest, most polite way you can say it. You could say it in a lot of other ways, but I get exactly what you're saying. Everybody knew. Because as I mentioned on here before, we had to file a motion to expedite the ruling, bump the ruling date up by like a couple weeks because we said we don't think Chester Weger, who's been diagnosed with stage 4 lung cancer, is going to make it to that July ruling date. So the court bumped it up. And then you know what? Chester would not have made it to the July ruling date because he died days after. And everybody knew that Chester was in such serious health that there's no way an appeal was going to proceed. All right, so let's wrap things up. I really appreciate you, Sally Cohen, and I just want to remind everybody of like the big point here. The point I'm making in this episode is it's one example, just the scratches evidence of the LaSalle County State's Attorney's Office, whose job is not even to investigate, knowingly ignored the Illinois State Police memorandum that made no reference to scratches, bruises, or cuts, and then intentionally and in bad faith, in my opinion, got a bunch of lodge employees to offer this dramatic false testimony at trial of Chester's scratches, cuts, and bruises that really, really damaged Chester at trial. It really did. And I really do think that if you could have attacked that and undermined that, you could have attacked and won the whole case. So it was very significant what the state did here. And clearly the state did it knowingly because they knew about that Illinois State Police memorandum. They called all those witnesses at trial, and none of them were asked about observations on Chester. So shame on the LaSalle County State's Attorney's Office for what they did. So that wraps it up for today. We will continue to talk about the case. We'll continue to talk about issues. Sally and I are still brainstorming on some legal options for Chester Weger. We're not done yet. The fat lady has not sung, not by a stretch. You have not heard the last of us. Stay tuned. Check out my Starved Rock Murders presentation on YouTube. Episodes 1 and 2 are up, and probably by the time this airs, episode 3 might even be up. I think people who are interested in the case will really enjoy it, and it'll be quite an eye-opener. I just am so factual, sharing factual information, educating people, and it's powerful. So everybody out there, thank you for your support. Stay tuned. We'll be in touch. Sally, good to see you.
Great to see you, Andy.